Hello and welcome to our conversation about Section 230. My name is Polk Wagner. I'm a professor at the University of Pennsylvania Law School and affiliated with the Center for Technology, Innovation, and Competition Center there. I'm here with my colleagues Christopher Yu and Shalom Balganesh, both also professors at Penn Law and the co-directors of the CTIC here at Penn. Guys, thank you for joining me. Today, we're going to talk about Section 230 and the President's executive order of late last week that was seeking a reinterpretation, a reevaluation, and maybe some rulemaking around that particular section. So before we get too much further, I want to ask my colleague Christopher, since he is truly the expert on communications law in the country, what is Section 230? Why is it important? Why are we talking about Section 230 at all in this context?
Section 230 has been called the most important statute for the internet success. And the question is why? What we saw was a concern that if a website was going to host a lot of content, people say a lot of things critical of other people. And if you make an out-and-out fabrication, you tell a lie, a knowing lie about someone, particularly about a public figure or some politically important event, you can be held for liable and be subject to civil penalties, and they can actually enforce against you. And the websites were saying, well, if we're potentially subject to libel suits, we're going to have to scrutinize every single post that's put up there. And even some ISPs took some down, and people said, oh, now you're editing, you're definitely liable, and you're not just a bulletin board that's posting other people's statements for which you have no responsibility. You clearly have responsibility now. And what we discovered is a lot of websites took a lot of content down or wouldn't allow people to post, and there was a huge concern that that would hurt speech on the internet. And as a result, in 1996, Congress enacted a statute which contained what we call Section 230 of the Communications Act, which has been interpreted by many people as saying granting immunity for people who just host bulletin boards and don't post any content. Actually, it says two things very specifically. It doesn't say you're immune, but it says you shall not be treated as a publisher, which in fact immunizes you from a lot of forms of immunity. But second, they created something called Good Samaritan immunity, which is if there's something you know that all readers are going to find offensive, you can take down a limited amount of material, and it's like obscene, lascivious, there's a whole bunch of adjectives that describe it. You can take down that material without being regarded as a speaker yourself, a publisher. Instead, you're just distributing other people's content, and one of the big analogies is a bookstore. If you are just selling other people's books, you didn't author them, you had no editorial control, you can't be held liable for those books. And why do we have that rule? If we held bookstores liable, they'd have to read every single book, and if there's any doubt about it, they would go against it, because why risk it? They're not going to benefit that much from it, right. And it would really hurt speech.
Yeah. So why are we hearing a lot about Section 230 in the news? Why is it now? Why is it controversial? It sounds like everybody decided in 1996 that this was important to foster the development of free speech and additional speech on the internet. Sort of what has happened that now makes it sort of a source of controversy and even political controversy?
Well, there's several answers you can give to this. One is economic, which is the companies that host content, Facebook, Google, Twitter now is very much in the news, have become economically very important and become targets, actually, of a broad-scale criticism, often on economic terms. So I find it quite distinctive that every political Democratic candidate for president took a position about we need to do something about these companies. The Trump administration has gone out of its way to do so. Enforcement agencies around the world have focused a lot of attention on them. Politically, what's also interesting is I think a lot of this has been affected by state attorneys general who feel like they need to protect their citizens. To some extent, the 2016 election, the perceptions of potential voter fraudulent communications happening there has increased in awareness, or a general sense that maybe we need to take more of a hands-on approach to these conduits. And then most recently, the two biggest things, just a couple of years ago, there was an amendment to Section 230 that was supposed to really help people stop sex trafficking. And then most recently, just this week, the president signed an executive order calling for a reinterpretation of Section 230 to stop what he perceives to be political bias in social media.
Right. So, Sean, let me ask you, what do you think the president is trying to do with this executive order? What's the, give us sort of the overview, the 30,000-foot view of what's the goal here?
So clearly, Section 230 and what the president was doing most recently is not part of some concerted, long-term, well-thought-out plan. It was triggered by, I think, the incidents involving Twitter's flagging of his posts for violations of their policy, and the claim that there is political bias is clearly driven by the recognition that that Twitter is only targeting his messages but is not flagging anyone else.
Right. So tell me, before you get too much further than that, how does that Twitter all of a sudden last week decided it was going to flag or tag some of his posts, how does that relate to 230?
Well, I guess part of the whole question is whether they're engaging in political censorship. Right. And by engaging in an editorial function, by censoring his speech, and let's be clear, right? They're not necessarily censoring his speech. In one view of the matter, what they're doing is adding more context to it, right? They're flagging it in a certain way and then directing to additional information. But that, in his view, is exercising editorial content. And the exercise of editorial content, in his view, triggers the potential for liability as a publisher or editor, which is, I guess, his theory, right? You're asking me to get into the mind of someone who may or may not have something in there as motivating this. So that's one view of his theory. And I think the argument is that Section 230 is what Twitter would then use to avoid liability for exercising that editorial function. And so the argument that he is purporting to make, at least the Twitter catchphrases are, revoke 230 and revoke the immunity that they could potentially rely on for the exercise of that editorial function.
Okay.
So what's really motivating the executive order is that entire political brouhaha surrounding his Twitter messages. But if you look at the executive order from a sort of legal and analytical point, there's a lot of fluff, which I suppose exists in a lot of executive orders, especially coming out of this administration. But the real meat, in my view, from an analytical point of view, comes in if you look at what he's trying to do with the two provisions in Section 230, which Christopher mentions. Section 230 has two important provisions for our purposes: 230C1, called the C1 provision, and the C2 provision. The C1 provision, as you'll see there, is really an exemption from treatment as publisher or speaker, right? It basically says that this interactive computer service shall not be treated as a publisher or speaker for the purposes of certain laws. And this is really, among other things, to provide a exemption of a certain sort from defamation liability or other areas where being identified as publisher or editor are the triggers for liability. Notice that C1 does not have any conditions imposed other than needing to be an interactive computer service to avail yourself of that exemption. C2, on the other hand, is this broader provision that says you are immune in some ways from civil liability. But notice that what C2 says, especially C2A, that any action voluntarily taken in good faith to restrict access or availability of material then gives rise to this potential immunity. But the precondition is that it needs to be exercised in good faith. And I think the question is the independence of these two provisions. It's my understanding that a overwhelming majority of understanding in the Section 230 jurisprudence is that these two provisions are independent, right? One is an exemption from publisher or speaker status, and the other is a immunity of sorts from civil liability. The categorical absence of conditions in C1 is apparent on the face of the statute. What the executive order does is it goes into this long discussion of how it is a policy goal of the United States government to promote free speech and avoid censorship on the internet, and that the best way of doing this is by not letting internet intermediaries, service providers, interactive services, be able to rely on C1 without any conditionalities. And so The analytical move that it makes is to say that the requirement of the action taken in good faith, that is there under C2A, now be transposed as a precondition into the invocation of C1, right? That's the big move. It's really contained in 2 paragraphs in the executive order. And what it does is it doesn't categorically say that's what we're redoing. It sets up this mechanism of rulemaking and an inquiry that is to be headed by the FCC to investigate the interaction, it says, between these 2 subparagraphs and to take the good faith conditionality in C2 and put it into C1 and flow from there. So I think that's the real analytical move. The important thing that it's doing, which I guess we'll talk about in a few minutes, is it's claiming that it's doing all of this not by way of making a new law, right? It's not saying we're making this proposal in an effort to amend the law. Why? Because from a purely analytical point of view, saying that would be to suggest that the current law is different from what you want it to be. Instead, the executive order is set up as an interpretation, right? It's saying that it has been our policy, we've always understood based on the intention underlying 230, based on the policy that Congress had in mind. And it could not have been that Congress wanted to give carte blanche protection without a good faith requirement. So under the garb of interpretation, it is trying to reintroduce the interactivity of these provisions. And that's, I think, the key analytical move.
Yeah, very interesting. Very interesting. So, Christopher, what do you see that interests you in the executive order?
Well, the obvious problem is the First Amendment, and that's what's generated most of the discussion online. And I think Ron Wyden, the sponsor of Section 230, said that this executive order is clearly illegal. And I would say there's a very strong argument under traditional First Amendment law that that's correct. So one of the basic fundamental ideas is that the First Amendment is the exact words are, Congress shall make no law abridging the freedom of speech. And that is a restriction by its own terms on the federal government, not private citizens. And there's a long line of Supreme Court cases that say, yes, private citizens and private actors do make choices. We call it editorial discretion or whatever. We make content choices all the time. What the Supreme Court says is the First Amendment says the only thing that it says is who the editor cannot be, and that's the federal government. And this ties back to the colonial experiences where they're saying the government cannot pick which speech you see and you don't see. And the Supreme Court says, well, when we had monopoly newspapers and all these other eras, yes, private actors effectively did that, but the cure would be worse than disease, because handing that power to the government is one of the dangers of handing that power to the government is one of the hard-fought lessons we've had in the American Revolution and otherwise. So what he's asking, what the executive order proposes is to have the government step in to restrict private speech in the name of the First Amendment. That turns it on its head, because the government's stepping in to change speech is exactly what the First Amendment is supposed to prohibit. And that, in fact, many people have called for a different interpretation of this, and many people, I think, would be on the other side of the issue from him, and it actually is going to create some really interesting problems with some scholars who've taken certain positions. But if I were really to try to boil this down, is to think about what this would mean, is that you would have to trust the government to intervene in a way that would determine whether something is politically biased or not, because he's asking the FTC to go do that. And the traditional idea we've had under the First Amendment, going back to Justice Brandeis, is if you think there's some bad speech out there, it's biased or it's wrong, the solution is more speech, not restricting that speech.
Right.
And in particular, labeling speech, providing more information, is never a First Amendment violation.
Right.
So they're suggesting that taking certain content, like informing people what the source of the information is, or who paid for it, or different things like that, we actually think to be speech enhancing and liberty enhancing and appropriate things for people to do. So
even if a service provider, so sort of taking the executive order's view here, if a service provider was applying tags, labels, masking or whatever content, and let's say they were doing it expressly for purely political purposes, right? We simply don't like conservative views on the Twitter platform. Is that do you think, one, immune from liability under Section 230, and two, is the attempt to withdraw that immunity a First Amendment concern?
Well, let me start first with the speech, and then we'll talk about 230. Think about the modern world of cable news. It is generally accepted that they have political viewpoints. They have strong editorial conceptions. This is said about many newspapers, whether it's the Wall Street Journal or the New York Times as well. And we consider that to be sort of within the First Amendment right to have your own political views. And actually, some of the communications literature says it actually enhances, to some extent, the communication, because if you want to see the viewpoint of the business community, you go to the Wall Street Journal. If you want to see a certain perspective, Fox News tends to adopt one more, and one that we all generally recognize. And so what we find is that sort of editorial voice in a private actor is a First Amendment value that we protect critically. The question here would be, can you use the imposition or the withdrawal of immunity to change their incentives to say certain things?
Right.
And this goes back to what was another Supreme Court decision, which is widely regarded as some of the most important ones in history. It's one of the most important ones in history, called New York Times versus Sullivan. The New York Times was covering the civil rights movement. And they got a couple of small facts wrong. I think they got the title of one of the officials or something that wasn't material, but they were reporting on the protests. And they were sued for libel. And the Supreme Court recognized that that sort of after the fact libel cases, the potential for immunity under libel suits, can chill speech just as effectively. And so in calling for selective imposition of libel cases against platforms like Twitter, the Supreme Court case law recognizes can violate the First Amendment just as easily as if they say they regulated the speech up front.
Right.
So, and after the fact payment threat can chill your speech as effectively as a before the fact order not to do it. And so that's the concern here. By withdrawing the immunity, you're exposing them to that kind of libel case. And that worry is that then they're no fools. They'll look at it and they'll change their behavior.
Right. Christopher, could I just ask whether the best way to understand this with your comment about the First Amendment is along the following lines? Because I'm trying to make sense of the C1, C2 interaction that which is by preconditioning the availability of C1 exemption on good faith behavior under C2 in whatever way that's understood, the executive order seems to be presuming that if you can't get the exemption under C1, you will be liable. What you are telling us is that even if you didn't act in good faith, you didn't need C1 to avail yourself of an exemption from liability, even if you don't want to call that blanket immunity, but an exemption because of the First Amendment.
The First Amendment does limit the scope of Section 230. Just because the statute says something, if it violates the Constitution is higher law. And so there is a recognition that libel cases can chill speech. We've actually put First Amendment limits on state libel laws to make sure that doesn't happen, because we recognize that many of the early libel cases were brought against newspapers who were criticizing and actually investigating corruption in local government. And going back to what one of the first things that happened in the framing, the Alien Sedition Acts, governments love using alien libel cases and sedition cases to go after people who are criticizing them. And so we actually have learned to give libel cases, to make libel cases that criticize the government, to make them very narrow and let the marketplace of ideas determine how we should think, based on not restricting what people say, but by allowing other people to say more.
Sure. So that makes perfect sense. I guess what I'm trying to figure out is what the true domain of Section 230 is, right? Because 230 is not imposing liability. What it is really talking about exemptions of certain kinds from liability. Everything that you're describing is the law of defamation and all that. Those are background conditions of liability that are set up in the background and have to be constrained by the First Amendment. So to the extent that we're talking about narrowing or expanding those exemptions in 230, what seems to be not being taken into consideration, and at least that's how I'm reading what you're saying, is the fact that there's a strong First Amendment bludgeon to these liability bases to begin with. In other words, is it not correct, based on what you're saying, that even without 230, you would be deeply skeptical of there being liability under state defamation law for the kinds of things that the executive order is being motivated by.
I think that's correct. I mean, so you have two questions. Are you liable under the state law? And second, is that liability consistent with the Constitution?
Right.
You can knock them out at either step. And
Yeah.
so if you're not liable under the statute.
So and let's be clear, when you're saying to knock them out, you're talking about sort of the example of Twitter takes down a tweet or labels a tweet or exercises its authority under its terms of service to engage in a publishing sort of act. They then get sued for libel, defamation, something like that under a state law theory. And it sounds like you and Sham agree that at that point, the First Amendment also plays a role in whether or not there's actual, at the end of the day, liability for that, right?
Right. So yes, I think that's right. If you look at state libel laws, you have to have published it. So you have to be a publisher.
Right.
C1 says certain people who are just conduits for other people's speech are not publishers. So up front, under the broad reading, the flat reading of Section 230 C1, if you're a bulletin board for other people's speech and you're not actually putting up any speech of your own or editing the stream, then you are not a publisher. And we don't even need to get to the First Amendment. You're not liable under state libel law. Fine. Now, if you were liable under state libel law, you would also have the First Amendment as a backup, but also you also have C2 as a backup, which is even if I exercise some editorial discretion to take down some posts, if I did it because they were obscene or lewd or that other list of items shown on the statute that appeared on the screen earlier, you still are immune from state libel law without even getting to the First Amendment. Now, what's interesting is this notion of good faith. It doesn't appear in the C1 publisher provision. And rewriting it in that way seems problematic by almost anyone who believes in conventional rule of law principles.
Good. Interesting. So let's, move a little bit to our thoughts about, what's going to happen here, right? So Christopher, what do you think? What is going to happen? The executive order calls for what it describes as a rulemaking. What does that mean? What happens?
Well, it's interesting. The executive order actually calls for a lot of different things. And it calls for one agency known as the Federal Communications Commission to reinterpret Section 230, and that's where the rulemaking comes in. There's a whole set of law that examines, that raises questions about whether the FCC actually has the authority to do that, and we'll have to go through that whole fight.
Right.
There will be...
So you're saying there's a lot of question about whether the FTC can even engage in a rulemaking of relevance to Section 230, right?
Actually, it's the FCC. That's another problem. There's more than one agency. The Federal Trade Commission, the FTC, is supposed to go after decisions to censor for political bias, although censor is only something government should do. Private censorship is a contradiction in terms. But what Twitter did as politically biased as a deceptive business practice by Twitter. They want the state attorneys general to get involved, and they're calling on a lot of different aspects to get involved in to try to change this dynamic.
Right.
And so what's going to happen? There's guaranteed to be lawsuits. Some of them will be constitutional, challenging the First Amendment. Some will challenge the legal authority. And the idea that this will get resolved before the election, I think, is essentially zero.
Yeah. So let's move and talk a little bit about what's a landscape of the internet, of speech on the internet, in the context in where there is no more Section 230, right? We are, 14 years after Section 230 was enacted. We know a lot more about speech on the internet now. Have we learned something about what that speech might look like? And maybe Sham, you want to weigh in on this first, and then we'll ask Christopher.
Sure. So my instinct is one of the interesting things coming out of this debate about 230 is how much bipartisan support there is for doing something with 230, and everyone seems to claim that it's problematic in certain ways.
Right.
I think that the main thing that I would take away from this is it's not clear that the omnibus nature of Section 230 in terms of attempting to regulate through two provisions, really, the entirety of internet speech and immunizing them from liability is the best way forward, right? To the extent that 230 was driven by the need for clear, bright line rules, I think the internet is now in an era where we need something more sophisticated than just blanket immunity or statements that you do not count as an editor or a publisher. I mean, this was crafted in many ways in the era in which we were thinking about the internet using metaphors from the real world. We now have a much more sophisticated sense of how the internet works, who does certain things, what content moderation looks like, what it means for users to actually be able to communicate directly. I think those kinds of questions merit a different approach that isn't really, I think, blanket, but much more nuanced and area specific. So if I had to guess in an ideally rational world where we're thinking about 230 reform, where we would head, it's probably in the direction of having more area specific civil liability immunities, right? We wouldn't refer to 230C1 in terms of you're not a publisher or an editor. We'd start talking about what does internet defamation look like in the context of, social media communications. What do we mean by communications to members of the public within Facebook settings? I think we talk in a much more sophisticated way rather than using these metaphors from the online and print world. I think that's the most important thing that I would guess we see going forward. And I think this is especially an issue when we look at the gamut of the forms of liability that have emerged with the internet, right? One of the things we know that in the last 20 or so years, if you look at the different kinds of liability theories that have all been tested to try and make sense of the regulation of speech on the internet, we see that we have a variety of different mechanisms that have either succeeded or failed. And I think what we need to really do is take a step back and understand how we regulate those mechanisms. I mean, speaking as a property person, the doctrine of cyber trespass, right, is a perfect example. I mean, it's clearly not something that Section 230 thought about, which is all focused on speech. But everyone knows the doctrine of cyber trespass, which is about saying robots and scrubbing information off a website, was all about speech regulation and the regulation of information. So I think what we need and will see is a much more nuanced approach, one that takes the technology seriously rather than just uses metaphors.
Yeah. Christopher, agree? You think we would be better off with a more nuanced, and we're in a better position now than we were 26 years, 24 years ago when we introduced this?
I think there's some signs we might be better off, and there are some signs we might be worse off. So let me think about this. So Sham, as a copyright expert, knows that copyright immunity is dealt with through an entirely different provision. So we're already in a bit of the subject matter specific world that Professor Balganesh is talking about.
Yeah,
that's probably a good thing because copyright and defamation have very different levels of importance in society and different dangers. And so we should have that. There was, as I mentioned earlier, an amendment 230 passed 2 years ago to try to prevent sex trafficking. So if someone posts something involving sex trafficking, you have no 230 immunity. Now, it looks very obvious. Who could be against that? I mean, sex trafficking is a terrible, terrible scourge, and anything that would make it limited would be better. Well, one of the interesting consequences that happened was Craigslist didn't just police its content for sex trafficking, it took down its entire personal site. And a lot of other places did very, very similar things. They sort of overreacted because anything that had the slightest risk of getting them in trouble under a sex trafficking law, they didn't want to have anything to do with it. And so what you start to see is these targeted subject matter interventions don't always stay within the realm that they're supposed to. And this is something that many of the defenders of 230 have been saying, is that you start to play too cute with it, you're actually still going to deter a lot of otherwise legitimate speech that have nothing to do with sex trafficking or whatever you're trying to stop.
Right.
There is one other thought I would throw out there, which is there is a potential for a political backlash, which is going to be interesting. As Professor Balganesh said earlier, I think absolutely correctly, there was a broad bipartisan support for scaling back Section 230 in some way. There was much less agreement about what way, but there was people on both sides of the aisle. This may engender some skepticism of attempts to reform 230 because there are people who are going to disagree with this move as sort of a step too far that may create more opposition to the bipartisan consensus that was emerging that Professor Balganesh referred to.
Yeah, interesting. All right. So, any final thoughts?
Back to one.
Yeah, go ahead.
which is looking at the executive order. I think one of the things which we should talk about is, this administration, and certainly this has been a political theme that's come up with its judicial appointments, has been very firmly committed to textualism as a form of statutory interpretation, right? Textualism being the view that the text of the statute should be really what dominates the understanding and interpretation of a law, and that judges should really adhere to the words of the statute as much as possible, and secondary considerations such as policy or even purpose play a secondary role to the text. And I think he's made that clear, and we know that that's been a dominant philosophy that a lot of his nominees and appointees to the court have adopted. But one of the things that struck me as odd in reading the executive order and the C2, C1 interaction is how directly atextual, I'll go even further, non-textual, actually I'll go even further, anti-textual is, right? Because in the garb of interpretation, remember, it's not saying we're changing the law. It's saying our interpretation of the law is that there's an implicit good faith requirement in C1. In many ways, it's hard to square with some sense of textualism. And I think that creates this sense that this is just an opportunistic move. I would like to see a really hard-nosed, sophisticated textualist show me how the two can necessarily be squared if it's an interpretive move. I can understand if it's a normative move that says the law should move there.
Right. Yeah. Interesting. Christopher, you agree with that? That's that it looks to you like this is a unusual interpretive move for an administration that has thus far been known as a fairly textualist based approach in their judicial philosophies.
Well, I would agree with Sham as far as it goes, but think that there's another interesting part to this, which is the attempt to move language from one provision to another to try to read the in good faith language that's in C2 into C1, it does contradict the textualist position that has traditionally been associated with this administration and the judges they've been appointing. What's interesting, though, is if you look at the first provision, which says you're not a publisher or a speaker, some courts have interpreted that much more broadly to create blanket immunity for everything, whether it's privacy or discrimination or different things, including liability that had nothing to do with whether you're a publisher or a speaker. And the pro-textual part of this move that would be reading 230 more narrowly is to side with the other line of cases, which says 230 doesn't use the word immunity. It says you're not a publisher or a speaker, and so you have to do the clear analysis of how much that effective immunity grants you. That amount of limiting 230 is completely consistent with textualism, and I think there's actually an interpretation question in C2, but I'm not going to go into all of that.
Right. Yeah, very interesting. So, any final thoughts as we end up here? Anybody have anything else they want to add, or any predictions about where this is going to go over the next several months? I know Christopher said earlier he thinks this is unlikely to do much but spawn a bunch of litigation, at least prior to the election. I have noticed that Joe Biden is also in favor of reform to Section 230 and potentially even the elimination of the so-called blanket immunity from liability. So that's an interesting perspective as well, where it seems to be an area in which parties might agree that something has to be done. Are we going to see anything on 230 anytime in the near future, or are we just sort of in this holding pattern until we get a new president?
I don't think we're going to see anything that happen soon. With Congress set up the way it is, there's no way they're going to amend the statute. We may see administrative proceedings that attempt to reinterpret it in the way and attempt to resolve the issues. Those are guaranteed to be challenged in court. And so definitive resolution is a long ways off.
Yeah.
What I find more interesting is the overall political valence of what's going on. So the last 4 years have seen a radical change in rhetoric. For about 20 plus years, the tech companies were the darlings of the American economy. They were the models of everything we're supposed to accomplish. And in the last 4 years, they've been so heavily criticized by everybody, both parties, state government, federal government, internationally. There was almost nothing, no developments that put them in a sympathetic light at all. And in fact, what's interesting to me also is the executive orders call for getting state attorneys general involved actually may find some fertile ground with some AGs who think that's good politics to go after these companies, and we'll have to wait and see.
Yeah.
What would be interesting is the reaction to the executive order has been very negative in many quarters. And what it'll be interesting to see is if this will mark a bit of a turnaround in the blanket criticism of what are sometimes called the hypergiants, the large tech companies. And this is something they can point to where even if they're going to reform 230, they're saying we have to be careful how it's done. Because if we're not careful, certain ways that 230 could be weakened could be used for overtly political purposes that could actually have the exact opposite effect of protecting free speech that moves are supposed to happen. And I think this will actually be this development may inform that debate in very interesting ways.
Interesting. Very interesting. Great. Okay. Sham, any parting thoughts?
Well, I mean, just to loop back where I began, to the extent that this is motivated by a feud with Twitter or similarly with any other big social media platform, it strikes me that the real issue that is probably going to come to the surface at some point is the extent to which we have a market that's dominated by very few players in the social media platform world. The extent to which, for instance, what Twitter is doing, there's no competitor, right? The fact that the president is dependent on Twitter to get his message out there and can't do it directly is really the real source of his complaint. And I wonder whether, if this 230 push fails, which I suspect, much like Professor Yu suggests, is going to happen, whether what's going to really become a major push, especially if the president wins re-election, I suspect is some kind of antitrust action. If he goes through the DOJ and starts pushing for examining the extent to which they have anti-competitive practices affecting consumer welfare, it'll be a certain directional shift, of course, for this administration. But I wonder, to the extent that there are major companies there and they're really going after the big players, of which there's significant market control, that might indeed be an avenue they look at.
Yeah, really interesting. So that's maybe a great segue for preview of a future conversation among the three of us, which is, should the big tech companies be broken up, right? Should we use antitrust and other tools of competition law to make sure that we do have a economically or financially competitive marketplace for ideas and not just one that's dominated by a few companies. All right. So anyway, this has been great. Great to talk to you guys, and we'll talk to you soon. Thanks so much.
Thank you, Paul.
Thank you.